Welcome to the second quarterfinal round of the largest ever international mock trial contest. We began with 48 teams and we are down to the Elite Eight. We're excited to see a great round of mock trial. A huge thank you to the teams for being involved and to these judges. We have an esteemed panel for you today. They're giving up their time. Nobody pays a cent to be involved with IMT, not a dollar in, not a dollar out. It's just based on the love of the game. And we're going to begin with a many-time outstanding judge winner, our presider tonight, Judge Stephen Noodleman. Take it away, sir.
Welcome, everybody. My name is Stephen Noodleman. I am a litigation partner at a 100-lawyer firm based in central New Jersey. And I have been judging mock trial on both the collegiate and high school levels for approximately the past 10 years. And I've been involved with IMT for the past two. I'm very happy to be here. And with that, let me first introduce Judge Ananta. Will you say something about yourself?
Hi, I'm Marcus. I am a first year at UCLA on the mock trial team, and I'd just like to tell you guys to hopefully stay in the moment, remember to have some fun, and enjoy the activity while you do it. I'll pass it on to Judge Nair.
Hello, everybody. My name is Meghna. I'm a fourth year here at UCLA, and I'm actually soon to go to law school. I'll be going to Columbia Law School in the fall. So I'm really glad to be here. Mock trial is something really dear to my heart. So I'm really happy to see all of you being involved and hopefully enjoying the activity as much as I do. So I hope to see a great round. Good luck.
Okay. So with that, let's call the case of State of Tilly versus Nova Wölff. As I said before, my name is Judge Stephen Noodleman. Our scoring judges look for the two buttons on the lower left of your screen. Remember to keep your audio off and video on until the end of the trial. So we lost Judge Ananta. We'll get him back. All right. You should also have your video set to hide all non-video participants. Also remember, all judges should be leaving comments. Well, that doesn't apply here, but needless to say, you'll fill out the score sheets and on the Google Forms and things will save along the way. Hopefully we have a timekeeper volunteer from each team. Could they appear and confirm that?
I will be timekeeping for the defense, Your Honor.
Okay.
I will be timekeeping for the prosecution.
Terrific. And you could feel free to put it in the chat if you want, if it helps your people to make sure they stay on time. So both sides have 4 minutes for opening statements, 18 minutes to share between two direct exams, 16 minutes to share between two cross-examinations, and 6 minutes for closing arguments. Time stops during objections. And with that, let's have the attorneys enter their appearances, please, starting with the prosecution.
Yes, Your Honor. Before we begin, the prosecution would like to ask for Your Honor's time preference, whether it be morning, afternoon, or evening.
Whatever you prefer. Where are you?
Los Angeles region.
So you're in an evening?
Yes, Your Honor.
Okay, and where is the defense?
We are in the Pacific, Your Honor.
So we're all in the evening, so that makes it unanimous. We'll go with evening.
All right, Your Honor.
Okay,
now,
why do you introduce yourselves over there on the prosecution?
Yes, Your Honor. Good evening, Your Honor. My name is Ryan Chen, and I, alongside my co-counsel, Mr. Syler Patel.
Good evening, Your Honor.
Good evening.
Represent the state of Tilly in today's case.
All right, terrific. Hang on. We're only doing introductions. Now let's talk to the defense.
All right, Your Honor.
Yes, Your Honor. Good evening. My name is Dana Elquza, and today I am joined by my colleague and good friend, Miss Livia Wiederkehr.
Good evening, Your Honor.
Good evening.
And together, we represent the defense in today's case, representing our client, Miss Nova Wölff.
Okay. Thank you very much, Ms. Elquza. Let me go back now to Mr. Chen. Does the prosecution have any preliminary matters for the court?
Yes, Your Honor. The prosecution would like to invoke Rules 603 and 615, which calls for the constructive swearing in and sequestration of all witnesses barring party representatives.
That's fine.
Your Honor, seeing as we are in a virtual courtroom today, regarding screen sharing, would you like us to ask permission before sharing or simply have the record reflect?
Yeah, I would like it that you do it and announce it at the same time. You don't need to stop and ask permission.
All right. That is all, Your Honor. The prosecution is ready to proceed to opening arguments.
All right, before we do that, let's go back to Ms. Elquza and see if she has any preliminary matters for us.
Yes, Your Honor. First, Your Honor, we'd like to designate our party representative as Miss Nova Wölff.
Okay, that's fine.
And next, Your Honor, we'd like to note that the defense will be asserting an affirmative defense in today's matter. Specifically, we will present evidence and prove that Miss Nova Wölff acted within her legal rights when she performed a lawful citizen's arrest.
Okay.
And next, Your Honor, we'd also like to bring the court's attention to case law Tilley v. Swift and Heim, 1989, which to some establishes that licensed private detectives can continue investigations even if instructed by police not to, provided that they just do not violate any laws.
Okay.
And finally, Your Honor, we'd also like to bring the court's attention to Stipulation 10 regarding Cotter Ashlock's parole violation, stating that Cotter Ashlock violated parole, but the district attorney's office has dropped all charges against them, and whether or not the DA will continue to press charges is dependent on Ashlock's testimony in today's trial.
Okay, we note that. Anything else, Ms. Elquza?
No, with that, Your Honor, we're ready to get the show on the road.
Terrific. And on that note, Mr. Chen, we are listening for your opening statement. Please proceed.
Yes, Your Honor. May it please the court. It wasn't protection, it was possession. Let me introduce you to Nova Wölff, a woman with a grudge, a woman who sought personal benefit, a woman who needed revenge. Now let me introduce you to Cotter Ashlock, the woman who was unlawfully restrained and kidnapped by the defendant, Wölff. Now, the story begins in sleepy Corleone town approximately 4 decades ago. Miss Ashlock's family has been a notorious presence for those 4 decades, and in the process made numerous enemies. Now, one enemy of the Ashlock family was poisoned in 2018. They were a close friend of Nova's, perhaps even her best friend. And now this loss is undeniably tragic, but it doesn't justify the defendant's following actions, especially not years later. Ever since 2018, Wölff's work as a private investigator has become increasingly controversial in the eyes of local authorities. For years, she has been harassing Miss Ashlock with cryptic notes, bloody knives, and threatening emails. This harassment all came to a head on March 11th, when Ashlock was found by police in Wölff's basement in a state of extreme physical distress. Wölff was told to keep an eye out for suspicious behavior, and only to keep an eye out, nothing more and nothing less. It wasn't protection, it was possession. That's why we, the prosecution, are accusing Nova Wölff of unlawful imprisonment and interfering with a police officer, which means that we have to prove to you 2 things today. First, that the defendant willingly and unlawfully restrained Cotter Ashlock, and second, that the defendant resisted the performance of an officer's duties. And we understand that by stepping into this courtroom today, we have taken upon a burden to prove to you beyond a reasonable doubt that the defendant was guilty of these charges. Members of the jury will meet our burden today through 3 facts: the story of how Nova was educated, how she investigated, and how she escalated. First, Wölff was educated. You will hear from Officer Larry Capolino, a well-respected member of Corleone's police force. She will testify to the fact that Nova Wölff had been educated several times in the value of de-escalating direct intervention. Yet instead of reporting the situation, Wölff acted on her own, recklessly. And then she investigated. We will call the victim herself, Cotter Ashlock. Ashlock will testify that she had been stalked by Nova Wölff. She will tell you the truth. She will tell you the experience of being hunted. Finally, the defendant escalated. Miss Ashlock will speak about how she was attacked from behind and forcibly trapped in Wölff's basement. She will speak about the horrors she saw in the basement that night, and she will show you just how scarring her experience was. Members of the jury, at the end of tonight's trial, my co-counsel, Syler Patel, will stand before you and ask that you find the defendant guilty of her crimes. He will ask you to see the truth. The fact that on March 11th, 2025, Cotter Ashlock was unlawfully imprisoned by Nova Wölff as a result of a long-standing vicious desire for revenge, and that she effectively hindered police investigation. He will ask you to see this trial for what it is, not a case of protection, but one of possession. Thank you, Your Honor.
Okay, thank you, Mr. Chen. Ms. Wiederkehr, we are ready. Please proceed.
She framed to stay free. It's late at night on March 11th, and Nova Wölff is standing inside her own home when Cotter Ashlock turns from frantic to furious. Tensions rise in seconds, voices escalate, and then, without warning, Ashlock reaches into her pocket and pulls out a knife. In that instant, this is no longer a conversation. It's a threat. And Nova, well, she's staring down at a blade held by someone angry and unpredictable, who's just feet away from her. Clearly, Cotter Ashlock was not the victim that night. She was a parole violator who needed a way out, and when her own actions put her freedom at risk, she did the only thing that could protect her. She framed to stay free. Today, the prosecution on behalf of the state of Tilly is suing my client for unlawful imprisonment and interfering with an officer. Now, in doing so, they've brought upon themselves the highest burden of proof in our justice system, meaning that they have to prove beyond a reasonable doubt that one, my client imprisoned another without that person's consent or the authorization of the law, and two, that my client obstructed, resisted, hindered, or endangered a police officer or interfered in the performance of such an officer's duties. And today, they'll fail to meet their burden because we'll prove two facts. One, she framed, and two, she would stay free. You'll learn from the neighbor that Nova and Ashlock walked out of Nova's house, and she did so freely. Then she chose to come back, and now this is the moment where everything changed, because you'll find out from Nova that when Ashlock returned, well, she was angry and aggressive. She pulled a knife. You'll learn today about something that we in the prosecution, well, we can both agree on. My client did restrain Ashlock. But here's the truth that the prosecution will try to twist. My client only restrained Ashlock after Ashlock pulled a knife on Miss Wölff. You'll hear today that she had to do so out of self-defense, just as any person would have done. And once the situation was controlled, well, my client, she called the police. Now, members of the jury, that's not unlawful imprisonment. That's self-defense. Now, why did Ashlock want to frame my client in the first place? Well, that leads us to our second fact. Cotter Ashlock would stay free. Today, you'll learn from the detective that Ashlock was not supposed to be in Corleone. It was a direct violation of her parole. Now, threatening someone with a knife? That was an even more serious parole violation. The bottom line is, Ashlock was facing extreme consequences. She was stuck and she needed a way out. So she framed to stay free. Now, members of the jury, it's your duty to look closely at the evidence and the facts of this case. At the end of this trial, my friend and co-counsel, Dana Elquza, will ask you to find my client not guilty, because we're confident that you'll see that Ashlock framed to stay free.
Okay, thank you, Ms. Wiederkehr. All right. And with that, let's make sure we've got our scores all set here. Hang on for 1 second. Okay, so does the prosecution have a witness?
Yes, Your Honor. The prosecution would like to call Officer Larry Capolino to the stand.
Okay, Mr. Chen, please. Okay, please. Do we have a defense lawyer? I don't see any defense lawyer who might want to.
Yes, Your Honor.
Okay, terrific.
My apologies.
No, it's okay. Now we're ready. Mr. Chen, please proceed.
Yes, Your Honor. Good evening, Inspector Capolino.
Good evening. Lovely weather, isn't it?
Yes, officer, it is. Now, could you please introduce yourself to the members of the jury?
Of course. My name is Larry Capolino, and I'm an officer at the Corleone Police Department, CPD for short. I've served there since 2011 and have been there ever since. You know, I've worked on so many cases, I'm just starting to lose count. But anyway, it's a pleasure to meet you.
It's a pleasure to meet you too. Could you also briefly describe your training and experience?
Of course. As a police officer, I've investigated in over 50 felony cases after graduating from the Maple Police Academy. My training included courses regarding investigative techniques, hostile negotiation, and the handling of evidence, which is a fancy way of saying I have to do more work and get paid at the same time. But, you know, it's always worth it.
I'm sure it is. Moving on, how are you involved in today's case?
Well, I was assigned as the lead investigator of this case.
Could you explain what that means, officer?
Sure. Basically, that just means I'm responsible for handling the evidence and interviews regarding Cotter Ashlock's alleged unlawful imprisonment on the 11th.
And officer, are you familiar with Cotter Ashlock?
Cotter Gabriel Ashlock is a known member of the Ashlock crime family. I've worked cases involving that family for over a decade. You know, thinking back brings me so many memories, the good and the bad.
Right. Do you also know the defendant, Nova Wölff?
Yes, I met Nova in 2018 after a series of investigations into the Ashlock operations.
And how did you meet her?
Well, she supplied tips unofficially without prompting. I mean, it made my job easier, so I wasn't complaining.
How specifically did Wölff help?
She gave us some useful leads, but, you know, I did feel to some degree that Wölff started to become more and more hands-on. It was puzzling to me that a civilian would be involved in this matter.
What makes you say that Wölff became more and more hands-on?
Well, sir, I noticed that Wölff often did things, let's say, their own way.
What do you mean by that?
Well, Wölff didn't really listen to police instructions and acted recklessly and independently. Not very normal for a civilian's job, especially.
And officer, when you noticed this, did you make Wölff aware of your opinions on their actions?
You know, as a police officer, I've been very vocal about my concerns. From then till now, I've warned her countless times that I wouldn't hesitate to arrest her if her actions ever went too far. I mean, I have my own job to do, and I can't let anyone skirt around legality, even though if there's some noble cause.
Now, directing your attention to March 6th, 2025, what happened that day?
On March 6th, I was notified that Cotter Gabriel Ashlock had recently been released on parole.
Did Ashlock adhere to the requirements of that parole?
No, on the 11th, I was told that Cotter Ashlock was reported to be in Corleone, violating those conditions. I can't say I was surprised, but it was unexpected.
So, officer, what did you do?
Well, I immediately called Wölff, knowing their history with the family, to warn her to not make any moves without the police backing her up.
What happened next?
Well, I was at dispatch when I received a call at 10:50 from Nova. Wölff had said that a known criminal was being held in their basement, awaiting police pickup. Well, the call was a little suspicious to me.
So why was it suspicious to you?
Well, I've seen so many cases where a civilian has been called dispatch to arrest a criminal, yet I rarely seen someone so mellow. So I went to Wölff's house where she said she had Miss Ashlock.
Upon arriving at the defendant's house, what did you...
Objection as to best evidence. May I be heard?
Yeah, I'm listening. Go ahead, Ms. Whitaker.
Your Honor, I believe opposing counsel just asked this witness to talk about suspicion and a specific phone call. However, they haven't admitted this phone call into evidence, and so therefore they can't talk about the specific characteristics of this phone call and what happened on this phone call without having admitted it.
Okay, I'll hear what Mr. Chen has to say about that.
I'm sorry, could opposing counsel clarify as to which testimony she is referring to?
Go ahead, Ms. Whitaker.
Yes, Your Honor. As to when the witness previously stated they believed the call was suspicious and how Ms. Wölff told the officer on the call to come to their house to pick up Ms. Ashlock.
Your Honor, may I be heard?
Yeah, I'm waiting on you there, Mr. Chen. I mean, the objection, as I recall, was something about best evidence, right? Which,
yes.
You know, I'm a little old-fashioned, so I tend to like to hear what rule number we're talking about. But I'm assuming that it's in here, and well, I'll get to it.
Your Honor, I have the rule number if you would
go
like
ahead,
it.
I'm listening.
It's 1002.
Okay, 1002. All right, Mr. Chen, we heard the rule number, 1002.
Yes.
Now you may be heard. Go ahead.
Thank you, Your Honor. Your Honor, it is not a violation of best evidence, as it's simply a conversation between the officer and Ms. Wölff. There is no directly stating what the contents of the exhibit are, Your Honor.
Yeah, Ms. Whitaker, I totally don't agree with that objection. You are overruled. Continue, Mr. Chen.
Thank you, Your Honor. Now, Officer Capolino, would you like for me to repeat my question?
Oh, yes, please.
All right. So, now, Officer Capolino, upon arriving at the defendant's house, what did you discover at the scene?
Well, we found Cotter Ashlock in the basement, bruised, disheveled, and visibly shaken, while seated on a chair. It looked pretty bad at first glance. We immediately got her out of there and secured the premises.
What steps did you take after getting her out?
Well, first, we questioned her about her night and procured the details about what happened to her leading up to arrival.
What did she say?
She told me that Nova Wölff had tied her up in her
Objection,
basement.
hearsay.
Okay.
Your Honor, may I be heard?
Well, I was about to say, what do you have to say about that, Mr. Chen?
Your Honor, this is admissible under hearsay through exception 803.3. Your Honor, this statement is not being used.
Mr. Chen, you got to give me a half a second. You gave me a rule number. I want to look at it. Give me a second. 803. No, that's okay. 803.3. Now explain. Why is 803.3 an applicable exception?
Your Honor, this statement is not being used for its truth value. If I may proffer, Inspector Capolino is about to testify exactly what they did only because of what they heard. It is through a subsequent action that we are trying to prove something, Your Honor.
Your Honor, may I respond?
Wait, I want to read 803.3. All right, I'm listening to you, Ms. Whitaker. Go ahead.
Your Honor, we still believe opposing counsel is using this for the truth of the matter asserted, as they're using the statement that Miss Ashlock was kidnapped for the truth. They're trying to prove that happened.
What do you say about that, Mr. Chen? It sounds kind of compelling to me.
Your Honor, if I may proffer again, Officer Capolino will continue and immediately testify towards her subsequent action, which is beginning that investigation into Wölff, Your Honor. We are not using this statement to prove that Nova Wölff had been restrained in Wölff's basement, but rather what happened after, Your Honor.
Okay, but the problem I have, Mr. Chen, is I'm not seeing that in 8033, what you just said. Now, maybe I'm reading the wrong rule, or maybe you didn't cite the right rule. But in any event, that doesn't help you. So therefore, the objection is sustained.
All right, Your Honor.
Continue, Mr. Chen. And as an aside, I do agree, as a secondary point, that it does strike me as it is being offered for the truth of the matter asserted. So go ahead.
All right, Your Honor. Now, Officer Capolino, what did you do after you questioned Nova Wölff? Well, I apologize, Cotter Ashlock.
Sorry, could you repeat your question?
What did you do after you began questioning Cotter Ashlock?
Well, I formally began my investigation into Wölff.
And what did you think after your full investigation was complete, officer?
Well, I believe that Wölff didn't have the full right to do what she said. I had even warned her.
Objection, speculation. May I be heard?
Sure.
This witness is testifying as to the specific legal qualifications that the defendant would have had to complete a citizen's arrest. This witness is not an expert in that field, and therefore they cannot make such statements.
Okay, let's hear what Mr. Chen says.
Yes, Your Honor. Your Honor, as we have established, Inspector Capolino has been on the police force for 15 years. It's entirely reasonable for us to assume that Inspector Capolino would have substantial knowledge about the law, including whether or not a civilian's arrest in this case is legal.
Your Honor, may I respond?
Ms. Whitaker, go ahead.
Under Rule 702, this is an improper expert opinion as
okay, Ms. Whitaker, that's all you needed to say. Mr. Chen, this is the third time I'm talking about a rule number, and Ms. Whitaker is 100% correct. You did not qualify this witness under Rule 702. The objection sustained.
Your Honor, may I make a response?
Well, you can, but you lost the objection, so there's really nothing to respond to. What you can do, Mr. Chen, yes, okay, is address Rule 702, because I'm ruling that it has not been addressed, which is what Ms. Whitaker was getting at. So that could be your response if you want, but that's up to you.
No, Your Honor. If I may, I shall continue.
Okay.
All right. Now, Officer Capolino, after Cotter Ashlock was removed from the residence, what happened next in your investigation?
Well, I continued interviewing Ashlock and—
Objection, lack of foundation.
Okay, what do you say about that, Mr. Chen?
Your Honor, the foundation has been laid, as we have mentioned how Officer Capolino has taken Cotter Ashlock outside of Nova Wölff's basement.
Yeah, you don't have to go too further, Mr. Chen. I don't understand the lack of foundation, Ms. Whitaker. Your objection is overruled. Continue, Mr. Chen.
Yes, Your Honor. Officer Capolino, were you able to finish your response?
No, I wasn't. May I continue?
Please do.
Yes. So I continued interviewing Ashlock and informed her of her legal options moving forward.
How did you go about that?
Well, we offered a deal for the truth. We wanted her to have her full cooperation and offered immunity from the charges she had. Well, this doesn't cover future actions, and rest assured, my ears will be ready for any news about her.
To conclude, what did you do after your investigation was complete?
Well, based on my training, experience, and the evidence I collected, I took Nova Wölff into custody for interfering with an officer and the unlawful imprisonment of Cotter Gabriel Ashlock.
Thank you, Your Honor. No further questions at this time.
Okay, thank you, Mr. Chen. Ms. Whitaker, cross-examination.
Yes, Your Honor. Good evening, Ms. Capolino.
Good evening, ma'am.
Now, let's start talking about the day that you received a call from Miss Wölff about Cotter Ashlock. On March 11th, you get a call from Nova Wölff saying that she needs you to come to her house, right?
Yes.
So you go there and you find Miss Ashlock, correct?
Yes, she was bruised, disheveled, visibly shaken.
Ma'am, I'm not asking what she looked like. I'm simply asking, was she there?
Yes, she was.
All right. And now she's been waiting outside the house and she told you that she had just been kidnapped and held by Nova Wölff, correct?
Yes, that's correct.
Well, let's see if those accusations are true. Now, first, she accused Nova Wölff of tying her to a chair, correct?
That's correct.
But she wasn't tied to a chair when you found her, was she?
She wasn't, but there were rope fragments.
So you'd agree with me that there was nothing preventing her from leaving.
There was no rope around her wrist, but I did saw some marks on her wrist.
All right, besides the marks and the rope fragments, she was not tied up to a chair, correct?
Yes.
So she was free to walk away once you arrived at the scene, right?
I guess so.
Now, Miss Ashlock also accused Miss Wölff of threatening her with a knife, right?
Yes.
And smashing her phone.
Yes.
Your Honor, let the record reflect I'm about to show the witness what has been pre-marked as Exhibit 11.
Okay.
Ma'am, what I'm showing you on the screen, that's the forensics report of the phone and knife, correct?
Yes.
It looks fair and accurate?
It does.
The defense offers Exhibit 11 into evidence.
Okay, Mr. Chen, any objection?
Yes, Your Honor. This evidence is hearsay.
Okay. All right, and let's hear what Ms. Wiederkehr has to say about that.
Yes, Your Honor. Exhibit 11 is admissible under Rule 8036 as it is a record of a regularly conducted medical activity. It was made near the time of treatment by the hospital personnel with specialized knowledge, and it was kept in the ordinary course of the hospital's business, making such records a regular practice of that institution. Additionally, the exhibit is certified and therefore it is self-authenticating.
Mr. Chen?
Yes, Your Honor. Your Honor, the opposing counsel has not laid the foundation through this witness of any of the prongs previously mentioned, Your Honor.
Okay, just so we're all on the same page, we're talking about the Exhibit 11 that's on the screen, right?
Yes, Your Honor.
The objection sustained. This
Your Honor,
exhibit,
motion to strike?
This is stricken and will not be admitted based on the lack of foundation as of this discussion.
Thank you, Your Honor.
Your Honor, may I have permission to lay the foundation?
You don't need you don't need my permission, Ms. Wiederkehr. How you try your case is solely up to you.
Yes, Your Honor.
Within the time limits you have.
Now, Ms. Capolino, do you normally create forensics reports?
Well, no, I'm a police officer. My forensics team do that.
My apologies. Your forensics team regularly creates these forensics reports, correct?
Yes.
And you review these forensics reports, correct?
I did.
Your Honor, the defense would like to offer Exhibit 11 into evidence.
Okay, Mr. Chen. Mr. Chen, what do you have to say about all that?
Your Honor, we still believe that the foundation has not been laid with prong A, that the record was made at the time or near the time with someone with knowledge, Your Honor.
Prong A of what, Mr. Chen?
Of 803.
I have a very fat rule book in front of me. Tell me where I'm supposed to look.
My apologies, Your Honor. Rule 8036.
Okay, 8036. Okay. Okay. And
Your Honor, may I respond?
hang on, Miss Whitaker. I want to know from Mr. Chen. 8036 has 1, 2, 3, 4, 5 parts to it. What is to be specific so Ms. Whitaker can respond, what are you saying there's not been foundation laid for which subparts of 8036?
Your Honor, we believe that the prong A has not been met.
Okay.
Yes, there has not been verification that the record was made or near the time by someone with knowledge, Your Honor.
Okay. Is that your only hiccup? So she's okay with B, C, D, and E?
Your Honor, I believe so.
Okay, good. All right, Ms. Whitaker, he narrowed it down for you. The objection is that you do not meet the 8036 subpart A.
Your Honor, as you can see on the exhibit, the date is March 12th, so that is, it does meet the requirements for the time constraints. Additionally, it is certified at the bottom by the lead forensics investigator, and so therefore it was reviewed by someone with knowledge, therefore fulfilling prong A.
Your Honor, may I respond?
Yeah, and this will be the last response. So
yes, Your Honor.
Go ahead.
We believe that the witness has to be questioned and the foundation has to be laid through the witness herself, rather than simply throwing the exhibit onto the screen and hoping that the jury will understand, Your Honor.
Mr. Chen is right in part on this issue, Ms. Whitaker, just so you know, okay? And for that, okay, I am agreeing that you did not meet part A. While there certainly is a certification, so that helps authenticate the exhibit. But you can't just put a document on the screen and say, well, it says this date and so on, and that means it's so. So he is correct. So the objection sustained.
Thank you, Your Honor.
Ms. Capolino, when was the forensics report created?
Oh, well, I believe it was created sometime earlier. I can't really remember the date. Apologies.
My apologies. Let me rephrase. The forensics report was created on was finalized on March 11th, correct? Or 12th, correct?
March 12th. Oh, yes, March 12th. That's correct.
Additionally, it was signed and reviewed by the lead forensics investigator, correct?
You sure are.
The defense would like to offer Exhibit 11 into evidence.
Okay. Mr. Chen, what do you say about that?
No objection, Your Honor.
Okay. Exhibit 11 is admitted into evidence. Continue, Ms. Whitaker.
Now, Ms. Capolino, under the section that talks about the knife, it states all of the partial fingerprints that were found on the knife matched Cotter Ashlock. No other matches were made. Did I read that right?
Yes, you did.
Now, under the phone section, it states, like the knife, only fingerprints of Cotter Ashlock were found on the phone. Did I read that right?
Yes, you did.
So they didn't find any fingerprints that belonged to Miss Wölff on the phone or the knife, correct?
Yes, well, that's what the exhibit says.
Now, moving on to Ashlock's injuries. Your Honor, let the record reflect that I'm about to show the witness what has been pre-marked as Exhibit 9.
Okay.
Ma'am, what I just displayed on the screen, that's the hospital's incident report, right?
It sure is.
It looks fair and accurate?
It does.
The defense offers Exhibit 9 into evidence.
Okay. I want to hear now what Mr. Chen has to say about that.
Your Honor, again, the objection is speculation. Hearsay, Your Honor.
Okay, hearsay. All right, Ms. Whitaker, we're listening to you. Why?
Yes, Your Honor.
And if you're going to point to a rule, you got to give me a moment to look at it.
Exhibit 9 is admissible under Rule 8034B.
Okay.
It is a statement made for the medical diagnosis or treatment, and this statement, it is a statement that specifically, as this rule states, statements are made that are made to describe a medical history, past or present symptoms, or sensations, their interception, or the general cause are admissible. Additionally, this exhibit is certified, and therefore it is self-authenticating.
Your Honor, may I respond?
Yes, go ahead.
Your Honor, if I may, I believe that the exception that opposing counsel is referencing is only under 803A, which is the criteria for being unavailable. Meanwhile, Cotter Ashlock is alive and available at this trial, Your Honor.
Wait a minute. Hold on. I'm not sure I'm following you, Mr. Chen. I'm reading Rule 803, which is the reason I ask people for the rule. And it says exceptions, regardless of whether the declarant is available as a witness. So I'm not sure I'm following what your argument is.
Your Honor,
why does it matter if, according to 803, it doesn't matter whether they're available as a witness?
Your Honor, I believe that the opposing counsel was using Rule 804B, Your Honor.
No, look, I'm kind of old around here, and I could have sworn I heard her say 803, subparagraph 4. Is that?
Yes, Your Honor.
Ms. Whitaker? Okay, so I did hear correctly. So we were talking about 803.4, Mr. Chen. So her argument is that this fits within 803.4B, if I heard her correctly. And therefore, it's an exception to the hearsay rule as it relates to number 9.
Your Honor, may I make a response to this rule then?
Yeah, go ahead.
Yes, Your Honor. Your Honor, Rule 803.4 says that this exhibit has to describe a medical history, past symptoms or sensations, inceptions, or general cause, while the foundation has not been laid for any of these prongs, 804B, Your Honor.
Your Honor, may I respond?
Yeah, I want to hear the answer to this. I want to know, Miss Whitaker, okay, because his argument isn't only based on hearsay, if I'm hearing him right. He's in some sense suggesting there's a lack of foundation for this. So I do want to hear that. So go ahead, Miss Whitaker.
Your Honor, I did specifically state when I was prior to entering the exhibit that this was the hospital's incident report for Miss Ashlock. Additionally, the foundation was laid on direct that Miss Ashlock did sustain specific injuries. Furthermore, I believe opposing counsel did object hearsay and has not made a lack of foundation objection yet. And so therefore, I believe 804 or 803.4B does.
Well, no, I did hear. I understand that you're trying to correct the court, but I did hear him say in his explanation under 803.4B that he saw no foundation for medical history, past, present symptoms, sensations, inception, or the general cause. And I wanted you to explain to me, you know, how any of that is so, because I haven't heard any testimony about any of that. So I kind of wanted to hear you explain that to me, and I missed it. So I'll give you this. You'll have the last word, Miss Whitaker, to try and explain how it is that there's been a foundation of this exhibit, okay, for you to fit within an 803.4B exception.
Yes, Your Honor. Opposing counsel did lay the foundation on direct that Miss Ashlock did sustain injuries and that the hospital did report on it. And so therefore the foundation was laid. Additionally, I did state that this was the hospital's incident report of Miss Ashlock. And so therefore enough foundation has been laid to know that this talks about past or present symptoms.
Okay.
Your Honor, if I may?
No, there's it's not needed unless Ms. Whitaker is a hospital administrator or a doctor or somebody who could bring this into some kind of a context. I don't see how the foundation for a medical record is coming in through an inspector, a policeman. So no, I can't follow the connection to get you to 804, 803 4B based on what we're looking at. And there's been no testimony about any of the detail that I see in 803.4b. So for that matter, the objection is sustained. This exhibit is not coming in at this point. Go ahead, Ms. Whitaker.
Yes, Your Honor. Ms. Capolino, you did after removing Cotter Ashlock from the residence, did you send Ashlock to St. Alfonso Hospital for a medical examination?
That's correct.
And the hospital created
Objection, Your Honor. Objection, Your Honor. Opposing counsel's question is compound.
What I don't know if I follow you, Mr. Chen. What is the compound question?
Your Honor, if I recall correctly, opposing counsel asked whether or not Officer Capolino brought Cotter Ashlock first to St. Alfonso's Hospital and then subsequently added on and gave and requested to have Officer Capolino take.
Okay, I'll sustain that. Break those questions down, Ms. Whitaker.
Yes, Your Honor.
Ms. Capolino, you sent Miss Ashlock to St. Alfonso Hospital for a medical examination, correct?
Yes, that's correct.
And the hospital created a report documenting that examination, right?
Yes.
And as part of that, your investigation, you obtained that report, correct?
I did.
Your Honor, let the record reflect, I will now be showing the witness Exhibit 9.
Okay.
This is the exhibit of the hospital's incident report, correct?
Yes, that's correct.
Does it look fair and accurate?
Yes, ma'am.
The defense offers Exhibit 9 into evidence.
Okay. Mr. Chen, what do you say about it this time?
Your Honor, again, objection, hearsay.
No, Mr. Chen, we're moving beyond that. Okay. Now, so her answer to you is 803.4. We've established that 803.4b. So now, you're supposed to explain to me why it is that Ms. Whitaker did not now go back and properly lay the foundation in order to get in under 803.4b.
Yes, Your Honor. Your Honor, the 803.4 exception B states that it has to describe a medical history, past or present symptoms or sensations, their inception or again, their general cause. Meanwhile, opposing counsel has not laid the foundation for how it is specifically a medical history and contains past or present symptoms or
No,
sensations.
this time, to Ms. Whitaker's credit, she went back and she fixed the problem adequately in the court size. The objection is overruled and Exhibit 9 is accepted into evidence under 803.4b. Continue, Ms. Whitaker.
Yes, Your Honor. Now, Ms. Capolino, based on this exhibit, Ms. Ashlock also claimed that she was hit on the head, right?
She did.
But according to this exhibit, the hospital staff didn't find any head injuries. Isn't that right?
Well, on this exhibit, it says so, ma'am.
Ms. Capolino, yes or no, the hospital staff did not find any head injuries?
Well, yes.
Thank you. No further questions, Your Honor.
Okay, Mr. Chen, any redirect examination?
No, Your Honor. May this witness be excused?
Well, yeah, if you have no redirect examination, that would be my next statement. The witness is excused.
Thank you, Your Honor.
All right. Let me just make sure I've got give me 1 second. Okay. Does the prosecution have any more witnesses?
Yes, Your Honor. At this time, the prosecution would like to call Cotter Ashlock to the stand.
Mr. Patel, very good. Please proceed.
Thank you. Good evening, Ms. Ashlock. Could you please introduce yourself to the jury?
Good evening. My name is Cotter Ashlock. That's Cotter, Cotter, and Ashlock, Ashlock. I know, it's not a name you typically hear often. You know that one kid you had in your kindergarten class that just couldn't spell their name for the life of them? Well, that was me.
It's nice to formally meet you, Ms. Ashlock.
Likewise.
Now, I won't waste your time here. Let's get right into it. Are you familiar with the defendant, Nova Wölff?
Familiar. Sure, let's go with that.
Well, how would you put it, Miss Ashlock?
Well, the first time I actually got to know her, the night ended with me being rescued by the police from Nova Wölff's basement after hours and hours in there.
So, Miss Ashlock, what happened between you and the defendant?
Simply put, I was tied up like a pig for roast. I woke up and I had no idea where I was. And it was so cold. Tell me, sir, have you ever been held against your will in a basement?
Objection, Your Honor, as to 403 more prejudicial than probative. May I be heard?
Okay, go ahead.
Yes, Your Honor. Well, this trial is currently in the guilt phase, not sentencing, and under stipulation 1, the issues of sentencing and punishment are bifurcated from guilt. Miss Ashlock here is testifying specifically about how terrifying the experience was, giving details about how she was treated like a pig in the basement, how cold it was, and this experience does not establish any element of unlawful imprisonment, which is why we're here today, Your Honor. Instead, it appeals to the jury's sympathy, which would be more prejudicial than probative.
Okay, I want to hear what Mr. Patel has to say about that. Go ahead.
Yes, Your Honor. We personally believe that the witness has not testified as to how she was treated like a pig, but rather provided details as to how she was tied up, saying that she was tied up like a pig for roast, which paints an image into the jury's minds. She simply wants to provide the jury with the most possible details to help them truly understand what happened on the night of March 11th.
If I may, Your Honor.
No, you don't need to. Mr. Patel, I'm going to tell you right now, very simply, I am sustaining the objection. And the reason, so you know, for future reference, I'm sustaining the objection because you did not address the objection that was raised by Ms. Elquza. Okay, your response was non-responsive to her objection. So on that note, she gave her argument under Rule 403, and I did not hear your response. So that being said, you have to listen closely to what the comments that are being made are. With that said, please continue, Mr. Patel. The objection sustained.
I understand. Ms. Ashlock, I now ask, did you know the defendant prior to March 11th?
I mean, I was familiar with the name, but I didn't actually meet Nova until that cursed day.
Could you elaborate?
I mean, after everything she did, I'm guessing that Nova just had it out for my family.
Miss Ashlock, what exactly did the defendant do to your family?
Oh, where to start? Well, firstly, Nova was full on stalking us. We couldn't go anywhere without constantly looking over our shoulders to see if we were being watched. It's really not the best feeling when you're just trying to get milk or something.
And how was she stalking you?
Well, she would send these pictures through email.
What kind of pictures?
Pictures of, well, us. Us when we thought we were alone. It was very disturbing.
Your Honor, let the record reflect I'm not going to screen share what has been marked and pre-admitted as Exhibit 12B.
Okay.
If we may be given a sec for a tech to pull that up. Now, Miss Ashlock, before I ask you any questions about this, I realize it may be scary for you to see some of this again. So for your sake, we'll just try to move through it pretty fast.
Thank you. I appreciate that.
Now, on that note, could you tell us what this exhibit is?
Um, this is an email that was sent to my personal inbox from what I can only assume to be Nova Wölff, which has pictures of me and my family.
And what was said to you in this email?
If you look at her reply to me, she told me that she would and torture me until I begged her to kill me, and then to the rest of my family as well.
Please take down the exhibit now.
Objection, Your Honor, if I may be heard.
Okay, go ahead.
Your Honor, we'd like to ask for everything that this Miss Ashlock has just testified about that exhibit to be stricken, as even though Exhibit 12B has been pre-admitted, they still have to have shown us that exhibit and stated that they would be using it during pretrial matters, or my apologies, Your Honor, rather during our captain's meeting, which they did not.
I've been doing this, even if it's for 2 years, Miss Elquza. I don't know that to be the rule. I mean, stipulation number 7 seems like it speaks for itself. I don't see anything about what you're saying in that stipulation, but I will hear what Mr. Patel has to say. Go ahead, Mr. Patel.
Thank you, Your Honor. I apologize, but I'm simply on a similar wavelength to you. We don't believe that we are required to show exhibits which are in the case packet to opposing counsel during captain's meeting.
Yeah, I mean, if it says it is admissible in their entirety at trial, is the first sentence of stipulation 7, and they may be shown at any part of the trial. He doesn't have to tell you how he's going to try his case in advance any more than you have to tell him how you're going to try your case in advance. So the objection's overruled. Continue, Mr. Patel.
Yes, Your Honor. Miss Ashlock, did it end there?
No, clearly, Nova never paid attention when she was taught about something called personal space. She even took it as far as threatening us.
What kind of threats, Miss Ashlock?
Well, just to name one, we received some kind of package. There's a bloody knife and a note saying that I will hunt you down to the corners of the earth if it's the last thing I do. Signed NW. Not exactly the kind of greeting you would expect.
Did this cause any major issues for you?
Objection, Your Honor, as to 1002 best evidence, may I be heard?
Sure.
Your Honor, Miss Ashlock has here just quoted word for word what that specific note had said, which under our case, Your Honor, is noted under Exhibit 7. So in order for Miss Ashlock to directly quote what this exhibit is saying, opposing counsel here would have to admit that exhibit into evidence, Your Honor.
Okay. Let's hear what Mr. Patel has to say about that.
Yes, Your Honor. For simplicity, may we be allowed to just pull up the exhibit and ask the witness a few questions on it and then enter it into evidence?
Again, I'm not telling you how to try your case, Mr. Patel, any more than I'm telling Miss Elquza.
Thank you, Your Honor. May I proceed?
Go ahead. I'm holding off on my ruling on your position, Miss Elquza, until after we deal with Exhibit 7, so I'm not forgetting about you. Go ahead.
Miss Ashlock, what is this?
I believe this is the note that we received as a package with a bloody knife.
Does it look changed or damaged in any way?
No, it does not.
Your Honor, at this time, we would like to move Exhibit 7 into evidence.
Okay. Ms. Elquza, any objection?
Yes, Your Honor. Objection as to Rule 404 character evidence. May I be heard?
Go ahead. I'm listening.
Your Honor, this exhibit right here is being offered to show that Nova Wölff had a violent or vengeful character and therefore acted in conformity with that character in today's case. And under Rule 404, evidence of a person's character or prior bad acts is not admissible to prove that that person acted in accordance with that character on a particular occasion, Your Honor. And that's exactly what opposing counsel is using this note for. To prove that Miss Wölff had actually acted in accordance with this character trait in today's incident, Your Honor.
Okay, I will now hear what Mr. Patel has to say about that.
Yes, Your Honor. This exhibit is not character evidence, as we are not using it to show that Nova Wölff has some sort of mannerisms or is a violent person. Rather, we're using this note to demonstrate the similarities between it and what was previously shown in the email, and that is true that Nova Wölff did in fact follow through on what they said.
Yeah, I don't see this at all as improper character evidence. That objection is overruled. This exhibit 7 is admitted into evidence. Please proceed, Mr. Patel.
Thank you, Your Honor.
Not the least of which is, Ms. Elquza, you kind of invited him to mock the exhibit by saying that, the testimony of what was said was the best evidence. Arguably, one could say, why didn't you say it was improper character when it was being testified to? Instead, you said to him, no, you need to produce the document. So now he produces a document. It's kind of like you kind of like, in some sense, waive the objection the first time around. If it was character evidence, I don't see it as character evidence anyway, but just so you understand that inconsistency doesn't help. So with that all being said, Exhibit 7 is admitted into evidence. Continue, Mr. Patel.
Yes, Your Honor. Ms. Ashlock, I'll re-ask the question. What type of threats did you receive?
Well, as you can see here, just name one. This note, I will hunt you down to the corners of the earth if it's the last thing I do, signed NW, came with a bloody knife. And again, not really the kind of greeting I would have expected.
Ms. Ashlock, did this cause any major issues for you?
Well, mostly I was scared, not only for myself, but family and those around me as well.
And do you know what started these problems with the defendant and your family?
Nova had a friend, Mark was his name, I believe, who owned this local restaurant near our home base. Great crispy duck there, by the way. Naturally, the Ashlocks offered him our protection. We know the area and we wanted to be friendly. If anyone wanted to be kept safe, my family would make sure it happened.
And did he accept?
No, and I imagine he would live to regret it because he tragically died a bit later.
Did Wölff have any contact with you before Mark's death?
Not really, but it may be a different story after the death, though.
Now, Miss Ashlock, to move on, where were you on March 11th?
I was in Corleone town. I know. I was on parole, and I wasn't supposed to leave New Hermitage. Trust me, after everything that, good luck catching me anywhere but home.
And could you tell us about what happened that night?
Well, around 10 or 11 p.m., I noticed someone about a foot or two in front of me because it was pretty empty in the street. They were acting, well, strangely.
Strangely how?
They were turning to look at me, eyeing me, watching me. I mean, sure, I looked good. I had that new pair of shoes. I was like just released and all. Sorry, I use humor to cope. It was a long night.
No worries, Miss Ashlock. You go on.
Well, it was just weird. It felt like they were just watching my every move. Then they crossed to the other side of the street where they sped up and ran away.
Did you see what they did across the street?
Yeah, they knocked on the door of a house on that street, talked to the person who answered, and would you look at that? Now I've got two creeps eyeing me down. Lucky me.
What happened afterwards?
Well, as if things couldn't get any weirder, the owner of the house closed the door, and the other person rushed to the house right next door, opened it, and ran inside. I don't know about you, but I've never seen neighbors do that in the middle of the night.
Was that the end of your experience?
I wish. I've still got a lot. So I keep going my way, right? And without any warning, bam, this solid chunk of cold, probably some kind of metal, I'm guessing, just whacks me straight over my head.
What happened next?
Uh, the next thing I remember was that I woke up and I was tied to a chair, like in the movies, except this time I wasn't eating popcorn on my couch. I mean, I had duct tape over my mouth, so how could I? It and it was just terrible.
Did you know where you were?
Not at the time, but I now know that it was no other than Nova Wölff's basement. Not the way I would have expected to get a house tour, but then again, Nova's very unpredictable.
And how did you come to find out it was the defendant's basement?
Well, uh, Nova was in and out of that basement. The number of times my heart stopped was probably unhealthy. Every time that door opened, it was unbearable. No one should have to experience that.
What did the defendant do?
Well, first I was straight fire interrogated about uh Jack Dong John Wong. I have no idea who it was. I kept saying that, but I was talking to a brick wall. Nova just couldn't seem to understand that I had no idea who this person was.
What happened after this rather confusing conversation?
Nova then proceeded to and smashed my phone against a wall. The shards of glass, I mean, it was unbelievable. She got angry with me because I didn't know some random person.
Miss Ashlock, was there anything else significant that night?
Let me think. Yes, how could I forget? Nova? Nova had a knife. Yeah, you heard me right. I was in her possession. Done scary things, seen scary people, but that was the scariest moment of my life.
Miss Ashlock, I am so sorry that you had to endure this and just relive this moment. Thank you for your time here in court and cooperation, Miss Ashlock. No further questions, Your Honor.
Okay, Mr. Patel. Ms. Elquza, cross-examination.
Yes, Your Honor. Good evening, ma'am.
Good evening.
Now, Miss Ashlock, I'd like to start today by asking you a bit about why you're here. Does that sound all right?
Yeah, it does.
Now, Miss Ashlock, you're here today because of a plea deal, right?
Well, yeah.
Because you broke the terms of your parole violation the night you were in Corleone. Isn't that right?
Yeah, that's long in the past, and I'm really trying to get better now. I'm working on that.
Well, now this deal, as you say, Miss Ashlock, it can grant you full immunity for that violation, right?
Yes, I believe those were the terms.
But Miss Ashlock, those terms, as you say, they only work if you tell the truth about what happened that night, right?
Then, well, that's why I'm here now.
Now, you being truthful, it isn't decided by the jury over there, right?
I'm sorry, I couldn't quite catch that.
You being truthful here today, it's not decided by the jury, is it?
I guess so.
No, Miss Ashlock, it's not decided by Judge Noodleman, is it, either, right?
I wouldn't know.
Miss Ashlock, it's the district attorneys that get to say whether or not they think you're truthful as they try to get a conviction, right?
Objection, Your Honor. Relevance may be heard.
Okay, go ahead, Mr. Patel.
Your Honor, opposing counsel has just gone on an entire pocket's worth of cross-examination about Miss Ashlock's reason for testifying here in court and who decides whether she's truthful or not. Quite honestly, the person who decides whether or not she's truthful has no specific bearing on the reason we're here today, which is the unlawful imprisonment charge and the charge of obstructing a police officer.
Okay. Miss Elquza, what do you say about all that?
Yes, Your Honor. Relevance is a very low bar to meet. And the purpose of my cross-examination right here, just this one pocket, is to just establish why Miss Ashlock's here today and her intent for giving the testimony that she's about to give. And if I may proffer, Your Honor.
You could.
I'm about to get into the specific parts that may not be truthful according to Miss Ashlock's story and how that aligns with that immunity and plea deal, which is exactly why Miss Ashlock's here testifying today, Your Honor. So the relevance.
That's okay. You don't have to go any further than Miss Elquza. Mr. Patel, she made a very lengthy explanation, which I followed completely. She could have been short-circuited a little bit and said she's doing this to show possible bias. That being said, the objection's overruled. Continue, Miss Elquza.
Understood.
Yes, Your Honor. Now, Miss Ashlock, just short and simple, it's the district attorneys that get to decide whether or not you're truthful as they try to get a conviction, right?
Yeah, I guess so.
But Miss Ashlock, you'd already acknowledged that there are parts of your story that aren't consistent at all.
Well, I'm gonna have to ask you to elaborate on that one, please.
Sure, no problem. Let's talk about what you said then. Let's set the scene for a moment. It's March 11th, right?
Right.
You're walking through Corleone town as you mentioned on direct.
Yes, I was.
And you feel something sharp hit the back of your head.
Yeah, cold, metal, hard.
And that hard thing that you felt hit your head, it was so hard that it knocked you out, right?
Yeah, it did. And then I woke up and I was in a...
Now, Miss Ashlock, you took a trip to the medical examinations office, the doctor, after that night ended, right?
I'm sorry, could you repeat that?
After this whole night ended, you took a trip to the doctor, right?
Sorry?
Miss Ashlock, after March 11th, that night after it ended, you took a trip to the doctor to examine you, right?
Yeah, I did.
Your Honor, let the record reflect that I'm now going to be screen sharing that medical examinations report, also pre-marked and admitted as Exhibit 9. Now, Miss Ashlock, just to make clear for the members of the jury here, you can see on this exhibit that it says, no head contusions were found on your head. Did I get that right?
Funny enough, I've actually never seen this. I mean, maybe it does, but I always say the body better than a biopsy.
Miss Ashlock, not asking about a biopsy or whatever. I'm simply asking you what you can read right in front of you. No head contusions were found, right?
Yes, I can read that.
So, Miss Ashlock, just to get this straight, something hit your head so hard to knock you out, but it didn't leave a mark.
I don't know, man, but all I know is I was hit and I was knocked out, and yeah, I ended up in a chair.
Well, Miss Ashlock, let's talk about that chair. Now, you said you woke up restrained, right?
Yes, I was.
And you're aware that while you were restrained, you were free to leave at any time, right?
Well, I don't know. I mean, Wolf never mentioned anything about that, and I was restrained, so how could I?
Well, Miss Ashlock, let's see if Miss Wölff actually did mention something about that. Now, during that night, you made a recording, right?
Yes, I did.
Your Honor, let the record reflect that I'm now going to be screen sharing that recording between her and Miss Wölff, also pre-marked and pre-admitted as Exhibit 2. Miss Ashlock, in this recording, Wölff told you, and I quote, that you are no one's prisoner, right?
Yeah, it says that there.
And Now, you mentioned that, you couldn't leave because you were restrained, right?
Yeah, I couldn't.
That you had rope tying your hands, preventing you from leaving. Yeah?
I did. I still got the burns.
Now, your hands were tied so tight that you got burns, and yet somehow you managed to take out your phone.
I already, I guess. It was a really long night, ma'am.
Right, ma'am. Not asking about the length of this night, simply asking you about your story. Your hands were tied so tight, you were still able to take out your phone and hit that recording button.
Yeah, well, I had easy access, and I was.
Okay. Okay, Miss Ashlock. Now I want to just end off here by talking a little bit about something else you mentioned on direct, the knife. Now you claimed that, Miss Wölff brought a knife and threatened you with it.
Yeah, she did. It was, yeah, yes.
And you claim that Miss Wölff was the one attacking you that night, right?
Yes.
And Your Honor, let the record reflect that I'm now going to be re-bringing up that exhibit of the medical examinations report, Exhibit 9.
Okay.
Now, Miss Ashlock, despite you claiming that you were the one attacked, right here it says that contusions were found on your knuckles, right?
I guess so. I remember the rope.
Objection, Your Honor. Lack of foundation may be heard.
Okay, Mr. Patel, what do you have to say here?
Your Honor, the witness has previously clarified that they have absolutely no clue about any details regarding this exhibit. Therefore, we ask that opposing counsel refrains from asking questions regarding it, as the witness has no prior knowledge.
All right. Let me hear what Ms. Elquza has to say about that.
Yes, Your Honor. The foundation has perfectly been laid here, as before entering this line of questioning, I asked Miss Ashlock after this night she took a trip to the doctor and the doctor examined her. Any reasonable person would be able to simply read what was found on her own body, not asking her to make an expert conclusion of some sort or talk about why what was found or how it happened, simply asking her about the marks that were on her own body, Your Honor.
Yeah, you sold me there, Ms. Elquza. The other point, Mr. Patel, in addition, just as a footnote, is your ship kind of sailed, right? You allowed the testimony to be when she went through this exhibit the first time and talked about contusions. You didn't object then. So I'm not totally sure of that. But notwithstanding that, just as a secondary point. Primary point is I do agree with Ms. Elquza that this witness has enough foundation that she's been discussing this and seems to know what went on and went to the hospital after this. So your objection's overruled. Continue, Ms. Elquza.
Yes, Your Honor. Now, Miss Ashlock, again, you claim that you were the one attacked that night, right?
Yes, I was.
Despite you claiming this, you were the one with contusions found on your own knuckles, right?
Yeah, but again, probably from the ropes.
Miss Ashlock, I'm not asking for an explanation here. Now, it even says that these contusions could come from hitting someone, right?
Yeah, but I was restrained. How could I?
Well, thank you, Miss Ashlock. I have no further questions, Your Honor.
Okay, I do note, Mr. Patel, there is a small amount of time you have if you want any redirect examination.
Yes, Your Honor, a brief one, if I may.
Well, as long as you're within the time, please proceed. Hold on, time out. How much time? I thought I saw a different number from the plaintiff. Oh, that's for recross examination. Okay, go ahead. I'm watching. Go ahead, Mr. Patel.
Yes, Your Honor. Opposing counsel asked about your medical records. Could you speak a little bit about those?
Yes, even though those doctors didn't find anything on me, I'm 100% sure that I was hit on the back of my head by something, likely metal. Again, I always like to say that the body speaks louder than the biopsy, and my body was telling me that I was hit in the head.
Thank you, Ms. Ashlock. No further questions, Your Honor.
Okay, Ms. Elquza, you have also a small window if you will have any recross examination.
No recross, Your Honor.
Okay, very good. Thank you. With that, the witness is excused. Does the prosecution have any other witnesses?
No, Your Honor. At this time, the prosecution rests its case in chief.
Okay. So now, before the defense puts on its case, does everybody agree to take a 5-minute break?
Yes, Your
Well,
Honor.
no, I know the judges will take the break. I'm asking if the other people, the prosecution and the defense, I don't hear from them.
Yes, Your Honor. The prosecution would like a 5-minute break.
Okay, good. We will come back. It is now
One.
Okay, we are back. And let us now turn to the defense. Please call your first witness.
The defense calls Charlie Reeves to the stand. Good evening.
Good evening.
Can you please introduce yourself to the members of the jury?
Yes, my name is Charlie Reeves.
What do you do for a living?
Well, I used to drive a yellow cab in New York City. Though I lived in London most of my life and made the choice to move from the Big Ben to the Big Apple. Drove that cab for a long time too. Saw everything you can imagine through that windshield. A couple years back, I retired, said goodbye to the traffic and the incessant honking, and then moved to Corleone, some peace and quiet.
So why are you here today?
I'm here today to talk about my neighbor, Nova Wölff, the one being accused of these ridiculous accusations, in my opinion. Here to share what I saw and what I heard.
So, how do you know Nova Wölff?
She lives right next door. Has for a while now. I still remember the first time we met. I knocked on her door because I needed a cup of sugar. Just one cup. She handed me the whole bag. Wouldn't even let me pay her back. After that, we'd talk over the fence, share dinners sometimes. She became one of my closest friends, actually.
Now let's talk about your relationship with Miss Wölff. Did you two spend a lot of time together?
Yes, more than I expected, honestly. When you retire, days, well, they grow long. She'd invite me over for dinner. We'd watch old detective shows. She'd always laugh at how unrealistic they were. Like medical show, perhaps. Watch one for Doctor, and they just tell you it's unrealistic. Except for maybe the pit. But I don't have much family nearby, so she kind of became family for me. We got so close. She even told me a secret.
What kind of secret?
Well, one night, she told me that she was a private investigator. At first, I thought she was joking. But then I thought about it. The way she noticed everything. Always watching, always thinking. It made sense.
Now let's talk about the night, or what happened on the night of March 11th. Can you tell me about that night?
It was around 11 p.m. I was walking home when I heard someone follow.
What did you do?
I was terrified. I mean, I did the only thing I could think of. I walked to Nova's house to tell her. She then told me to go back home and said that she would handle it.
Objection, Your Honor, as to hearsay.
Your Honor, may I respond?
Well, yes, go ahead, Ms. Whitaker.
Your Honor, this falls under the exception effect on the listener, as these statements directly impacted this witness as well as the defendant's subsequent actions as they decided to go home and let Miss Wölff handle the situation.
Okay. Mr. Patel, what's the response to that?
Your Honor, whether or not this is being used for the effect of the listener, it still carries large truth value, as it does show that Nova Wölff went on to handle it.
And anything else, Miss Whitaker?
Yes, Your Honor. We are not using this to show whether Nova actually went to handle it or not. Instead, we're trying to show how this impacted this witness's subsequent actions, as they did then, as a result of hearing this, decided to go home, which impacted the rest of how this night ran.
Yeah, no, I got to confess here, Ms. Whitaker, I do see the truth value in this. The objection is the objection is sustained, so it's stricken. Continue, please.
Yes, Your Honor. Now, Mr. Reeves, were you ever able to see who was following you?
No, I wasn't able to make out the face. I was so terrified. So I went straight to Nova and I told her what happened.
And what happened next?
Well, once I got back home from my home, I could audibly hear Nova yell, "Ashlock!" and then a door slammed. That's when it hit me.
Hearsay.
Okay. I'd like to hear what Miss Whitaker has to say about all that.
Yes, Your Honor. Under Rule 8032, excited utterance, a statement relating to a startling event or condition made while the declarant was under a state of stress, of excitement that caused it is admissible. Clearly, she was under a lot of stress confronting a dangerous criminal, and thus this statement falls under the hearsay exception.
May I respond, Your Honor?
Got better make it good, Mr. Patel. I'm listening.
Yes, Your Honor. It's speculative to assume whether or not Nova Wölff was under distress. We have also heard no foundation as to whether or not Nova Wölff heard this immediately after or while seeing or experiencing something. Therefore, it is still hearsay and does not meet 8032's requirements.
Your Honor, may I respond?
No, because I don't agree with Mr. Patel. He didn't make it good enough. Sorry, Mr. Patel. The objection's overruled. Continue, Miss Whitaker.
Yes, Your Honor.
That is, just so we're clear, that is an excited utterance based on the testimony that was given. Continue, Miss Whitaker.
Yes, Your Honor. Now, Mr. Reeves, how do you know Cotter Ashlock?
Well, sorry, just to finish what I was saying, because I don't believe I got to finish. After I heard all those noises, that was when it hit me that Cotter Ashlock was one who followed. Now, as for how I know Cotter Ashlock, Nova told me that he was a member of the famous Ashlock crime family.
Did you ever see him that night?
Yes, I tried to stay out of it. I really did, but well, I guess my curiosity got the better of me, and then I went downstairs to see what was going on. I saw Cotter Ashlock burst out of Nova's front door. He was panting heavily.
Did you see anyone else come out of that house?
Nova did too. Well, she stood in the doorway and said something to Ashlock, but I couldn't quite figure out what. Then Ashlock walked right back into Nova's house.
After they both walked back into Nova's house, what happened next?
Well, things they got really crazy. Lots of shouting, furniture scraping, and crashing noises from things being knocked over. I also heard someone fall or be pushed against a hard surface. Then I heard Nova's voice more clearly.
What did she say?
She said something like, "You have a knife."
Objection, Your Honor, hearsay.
Okay, Miss Whitaker, what do you have to say about that?
Yes, Your Honor. Under Rule 8032, excited utterance, a statement relating to a startling event or condition made while the declarant was under a state of stress, that caused
hold it,
David
Miss
and Miss
Whitaker,
Wolff.
Miss Whitaker. I just have to, because only because it'll rub me the wrong way. The word is declarant, but that's
My
okay. No,
apologies.
that's all right. This is a learning experience, declarant, but that's okay. I want to hear what Mr. Patel has to say. I follow the excited utterance. Mr. Patel, I'll give you another hint. You better make it good. I'm listening.
I'll try my best, Your Honor. Your Honor, there is no possible way that the witness could have known what was happening inside of that house. Therefore, there is no possible way we can know whether or not this is an excited utterance. This is shown in the fact that we don't know what was happening when Nova Wölff said this, and it carries heavy truth value as it is to assert the point that Ashlock had a knife.
I'm not sure. I don't know about you over there on the West Coast there, Mr. Ashlock. Here on the East Coast, if someone presents a knife to me, I say, hey, there's a knife, to me that would strike me as an excited utterance. Therefore, the objection is overruled. Continue.
Yes, Your Honor. Now, Mr. Reeves, can you tell me what specifically Miss Wolff said?
Well, as I mentioned, I heard her shout that you have a knife. Then I heard heavy footsteps. Then Nova yelled something like, stop, or let go. Finally, a super loud scream of pure terror. I can hear it just now. It just haunts me to this very minute.
Objection, Your Honor, speculation.
Okay. What do you say about that, Miss Whitaker?
Your Honor, this witness is not speculating as they're testifying to their own feelings as they can just hear it now and
No, I want to hear what Mr. Patel says. What is the specific piece of speculation in your mind there, Mr. Patel?
Your Honor, the part that we believe is speculation is the fact that it was a scream of utter. Sorry, I don't believe I remember.
Pure terror. The objection sustained. That is absolutely speculation. Continue, Miss Whitaker.
Motion to strike, Your Honor.
That testimony is stricken, and the jury will disregard it. Keep going, Miss Whitaker.
Yes, Your Honor. Now, do you know if the police ever got involved?
As a matter of fact, yes. They showed up a little while after. I, of course, told them everything I saw. I just really hope that Nova's okay. Never forgive myself if she got hurt. Because of me.
Thank you. No further questions, Your Honor.
Okay, thank you, Miss Whitaker. Cross-examination, Mr. Patel.
Yes, Your Honor, may I proceed?
Please proceed.
Good evening, Mr. Reeves.
Good evening.
Let's start about talking about you. One of your biggest hobbies is reading detective novels, right?
That is correct. Reading detective novels and watching detective shows with Miss Wölff. Yes.
Yes, and when you moved to Corleone, you met an actual detective, right?
I did, yes, although I only learned that fact after me and Miss Wölff became close, yes.
Yeah, just to clarify, this detective was your very own neighbor, wasn't she?
She was, yes.
Now, Detective Wölff was extremely helpful when you first moved in, right?
Very helpful, I would say so, yes.
And after your very first impression of Wölff, you thought that she was a good kid, didn't you?
I did, yes.
As a matter of fact, you were so fond of Miss Wölff that you started to consider her as your very own grandchild, right?
Well, our relationship was more of friendship, but I did draw parallels with my grandchildren, yes.
I'm sorry, is that a yes, you did believe that she was similar to being your own grandchild?
Some aspects of our relationship, yes.
Now, let's talk a little bit more about Nova Wölff. You frequently spoke with Wölff about her detective career, right?
Relatively frequently, I suppose. I mean, once again, most of it came up over our shared passion of watching detective crime shows, but...
Understood. You learned that Miss Wölff moved to Corleone to help hunt down the Ashlocks, right?
Amongst other reasons. I understood she wanted to change the scenery, amongst other things, but yes, that was certainly a part of it.
You also learned that she helped provide many details to help arrest Cotter Ashlock, right?
not fully aware of all those details, but my understanding is she was definitely involved in some shape, yes.
And you also learned she helped arrest many other criminals from the Ashlock family, didn't she?
She mentioned having an illustrious career, yes.
Yes, but just to clarify, a career very related to the Ashlocks, right?
That is correct, yes. Though I might add she's a private investigator, primarily.
Now, let's move on from Wolf and talk about you. You didn't know much members of the Ashlock family personally, did you?
I did not, no.
So, if I asked you to, you couldn't match any Ashlock names to Ashlock faces, could you?
I mean, I've heard enough about them to kind of get an impression, I would imagine. Scary-looking face, perhaps?
But just to clarify, you don't know any of them well enough to match them, do you?
I don't, and I wouldn't want to, no.
Now, Mr. Reeves, in the kindest way possible, of course, you are a man of older age, right?
That is correct, yes.
And you'd agree with me in saying that with age, your senses begin to dim, right?
I prefer to think of myself as a fine wine, or cheese. You age better, no? I'm still
Understood.
sharp as a tack, I would think.
Understood, Mr. Reeves, but you'd agree that generally, as you age, your senses begin to dim.
Objection, relevance. May I be heard?
Sure.
Opposing counsel is asking this witness about senses generally dimming with older age. This has nothing to do with today's case.
Response, Your Honor?
Okay, yeah, I'd like to hear what Mr. Patel has to say.
Yes, Your Honor. This witness, being of older age, has a lot to do with specifically how your senses adjust as you age. Specifically because this specific witness, all of the evidence they provide is related to what they saw, heard, or felt on the night of March 11th. Therefore, this is extremely relevant.
Your Honor, may I respond?
Sure.
Under Rule 402, evidence is only relevant if it makes a fact of consequence more or less likely. Opposing counsel has not listed any specific facts of the case that would be impacted by the general ability of older people to have dulled senses.
Response, Your Honor?
No. No. I'm going to allow this line of questioning, and I'll talk about it during the comments. So the objection's overruled. Continue, Mr. Patel.
Understood, Your Honor. Mr. Reeves, I'll re-ask. You'd agree that in most cases, with age, your senses begin to worsen, right?
I suppose in some cases, yes.
Now, let's finally talk about the night in question. You weren't standing next to Nova Wölff any point after she took Ashlock, did you?
I was not, no. I heard it from my house, and then I walked out when I observed that altercation when Ashlock entered Miss Wolff's house.
Yeah, as you just said, you observed the incidents from your own property, right?
That is correct, yes.
Now, just to clarify, you don't estimate the distance between your house and Miss Wolff's house in feet or yards, do you?
I would not, no.
And now, sir, you'd agree with me in saying that it's dark during the nighttime, right?
The nighttime is dark, yes.
Yes, and you'd also agree with me in saying that it's harder to see in the dark than it is to see in the daylight, right?
For some, I mentioned I'm a newer cab driver, so I have gotten used to driving in the dark and being able to see things in the dark. So, in general, I'm a bit more versed in nighttime viewing, perhaps, but I can see your point, yes.
Yes, sir, just to clarify, just in general, it's harder to see in the dark than it is in the light, right?
It's harder to drive in the dark and see in the dark, yes.
Now, during the interaction, the majority of what you heard was broken into pieces, correct?
That's correct. Yes, I heard the shouting, then there was a brief gap. I walked outside, and then I saw that horrid thing happening. Yes.
I'm sorry, sir. Is that a yes to my question?
There were gaps, yes.
Now, you never claim to give exact times for when events happen, do you?
I do not, no.
And you also never claim to have seen the entire interaction from beginning to end, do you?
I was in my house, so no, I did not see the entire interaction, no.
Thank you for your time here in court today, Mr. Reeves. No further questions, Your Honor.
Okay, thank you, Mr. Patel. Ms. Wiederkehr, any redirect examination?
No, Your Honor. May this witness be excused?
With that, the witness, yes, the witness is excused. Thank you, Mr. Reeves. Okay, does the defense have any other witnesses?
Yes, Your Honor. We'd like to call Miss Nova Wölff to the stand.
Okay. Okay, Ms. Elquza, please proceed.
Good evening.
Hallo, guten Tag.
Could you please introduce yourself to the jury?
My name is Nova Wölff.
What do you do for a living, Miss Wölff?
I'm a private investigator, certified by the Tilly's Detectives Association.
Why are you here in court today?
Because I was arrested for detaining a criminal. But they flipped the whole story to treat me as the criminal. So I will tell you the truth.
Miss Wölff, before we get into that, did you know the Ashlock family?
Yeah, unfortunately, I do.
Can you describe your history with them?
They killed my friend, my best friend, Mark Vukovic. They poisoned him.
Do you know Cotter Ashlock specifically?
Not personally. I knew he was part of the family and what kind of criminal he was, though. But I hadn't met him until that night, March 11th.
Miss Wölff, before we get into that night, March 11th, I want to ask you something. Do you dislike Cotter Ashlock?
No. I never even
Objection,
met
Your
him
Honor.
before that night.
Objection, Your Honor. Opposing counsel's question calls for irrelevant testimony.
I don't understand, Mr. Chen. What part of what is irrelevant? So Ms. Elquza could respond.
Your Honor, I believe that the question as to whether or not Nova Wölff personally dislikes Cotter Ashlock is completely irrelevant to the matter at hand, which in tonight's case, we are discussing whether or not Nova Wölff imprisoned Cotter Ashlock.
Okay. Ms. Elquza, what do you say about all that?
Yes, Your Honor. Again, relevance is an extremely low bar to meet, and this specific statement goes directly into what prosecution is trying to prove today, specifically as to Miss Wölff's motive. This statement is just trying to clear up whether or not Miss Wölff actually did have the specific motive prosecution is bringing up today, specifically just stating Miss Wölff's attitude and perception and relationship with Cotter Ashlock, which is extremely relevant, Your Honor.
Okay. What do you say about that, Mr. Chen?
Your Honor, I believe that it is still completely irrelevant, as it has been established that first, Nova Wölff is not familiar with Cotter Ashlock, and that is enough for us to know as the jury, Your Honor, as the questions previously were whether or not she was personally acquainted with Ashlock.
I'm not seeing it your way there, Mr. Chen. The objection's overruled. Continue, Ms. Elquza.
Yes, Your Honor. Miss Wölff, do you dislike Cotter Ashlock?
No. My anger has always been for Jay Kuang. He is the one who actually poisoned Mark. Cotter was just someone connected to the family. I was investigating the Ashlocks because of what happened to my friend. But I did not have anything personal against Cotter specifically.
Miss Wölff, you mentioned the night of March 11th. Let's talk about that. How did that night begin for you?
It was chaotic. I was home watching Tatort, a German crime show. My favorite, when my neighbor, Charlie Reeves, knocks on the door. He looked so scared, said someone was following him.
So what did you do?
I tell Charlie to head back home. He's an old fellow and it was getting late, so I assure him I would figure it out so he could get some rest. When he left, I looked outside to see who it could be.
Who did you see outside?
Cotter Ashlock.
What did you do after seeing Ashlock?
I recognized him immediately. I knew she was on parole from what the police told me, and not allowed in Corleone. I decided to confront her and ask why she was there.
Why did you decide to invite them inside?
To talk, to ask questions. That is all. I wanted to know what she was doing there and what she knew about Mark's death. I just wanted answers. And as a PI, I'm allowed to ask questions.
Miss Wölff, did you restrain Ashlock then?
No, I had no intention of doing that in the first place. Like I said, I just wanted to talk.
Well, so what was that conversation like between you and Miss Ashlock?
Tense. I accuse her of serious crimes. She became defensive and seemed angry. Then she said she was leaving.
Objection, Your Honor. Speculation?
What part of what is speculation, Mr. Chen?
Your Honor, Miss Wölff is testifying towards how Cotter Ashlock seemed angry or defensive and had negative emotions, which she cannot tell simply with her five senses, Your Honor. This is speculative towards what other people feel.
Okay. All right. I want to hear what Ms. Elquza says.
Yes, Your Honor. This statement that Miss Wölff here is making is perfectly within her own rationally based perception. As
What
she said,
I asked Mr. Chen, and I didn't know if I gave the answer. What statement are we talking about? There were a couple of things that Miss Wölff said, and I tried to understand what the specific. And I want to go back to Mr. Chen for a minute. What specifically that Nova Wölff testified to that you are objecting to?
Your Honor, Miss Wölff testified towards how she believed that in their conversation, Cotter Ashlock was becoming defensive and angry. But these adjectives are not within her five senses. Instead, these are labels that she has placed with speculative elements.
So Ms. Elquza, if I heard her correctly, said that these things about defensive and angry were within Ms. Wölff's rationally based perception. Is that what you were saying there, Ms. Elquza?
yes, Your Honor, and I also wanted to say that this witness here said seemed angry. We don't have a court clerk here today
Right.
taking
That's kind of why and I'm old and I don't have a good memory. But that being said, yeah, I have a hard time with that, Mr. Chen. I'm not sure if it's within her perception that she can have an opinion that the person looked angry and felt that way and seemed defensive. So I will allow that testimony. The objection is overruled.
Yes, Your Honor.
Yes, Your Honor.
Continue, Ms. Elquza.
Miss Wölff, what was that conversation like between you and Miss Ashlock?
Like I said, she seemed defensive and angry. Then she said she was leaving.
What happened then?
I told her she was free to leave, but if she left, I have to call police for violating parole. She
Objection,
hesitated.
Your Honor. Opposing counsel's. Sorry, I apologize. Miss Wölff's testimony is hearsay.
Okay. Ms. Elquza.
Yes, Your Honor. Your Honor, this would not be hearsay under exception 801C. The statement is not offered to prove that she was actually legally free to leave, but rather it's simply offered to show the effect on the listener, specifically that after hearing that she was free to leave, Miss Ashlock.
Hold it. What did you point us to, Ms. Elquza? What number?
80 under 801 801C, Your Honor.
Okay, okay. So what is the I'm not sure I understand. Go ahead. What under 801C is the problem here?
Your Honor, specifically just under subsequent action and effect on the listener, if I may explain.
Go ahead.
Your Honor, we're just using this statement to prove not for the truth of the matter that Miss Ashlock was in fact free to leave, but rather what she did after hearing this statement, that Miss Ashlock did in fact leave after hearing that she was free to leave, which explains her subsequent conduct, not the actual truth of the matter of this statement, Your Honor.
Yeah. Okay. I'll hear what Mr. Chen has to say. Go ahead.
Your Honor, I don't believe, first of all, I don't believe that 801C is the exception to hearsay, Your Honor. I believe that's simply the definition for it.
Okay. Well, Ms. Elquza is saying it's not hearsay because it's not being offered to prove the truth of the matter asserted under 801C2. That's what I had heard her say. So what's your response to that?
Your Honor,
She's saying it's showing the effect on the listener, not being offered for the truth of the matter asserted. I heard her argument. So what is your response to that?
Your Honor, I believe that the statement that Miss Wölff is saying still has heavy truth matter, even if I apologize, opposing counsel claims that it is not being used for the truth of the matter, Your Honor. I believe that it still has heavy truth value.
Yeah, in this particular case, Mr. Chen, I don't agree. I do see it having the effect on the listener. So, on that grounds, Ms. Elquza is correct. The objection is overruled. Continue.
Yes, Your Honor. Miss Wölff, what happened after Miss Ashlock left?
She came right back.
Or before she came back, what did you tell her during your conversation?
I told her she was free to leave.
What happened after?
Well, when Ashlock came back, it was like a switch flipped. She exploded, screaming, throwing things, completely unhinged. Then she pulled a knife and threatened to kill me.
So, Miss Wölff, did you threaten her with the knife?
No, she pulled the knife.
So, what did you do after they threatened you with a knife?
I restrained her. I will admit that my combat was subpar, but I had to tie her to a chair to stop her from hurting me. I called the police shortly after, as soon as I could make sure Ashlock wasn't going anywhere to hurt anyone else.
Miss Wölff, you mentioned that you called the police. Would you recognize a recording of that call?
Yeah, I would.
Your Honor, let the record reflect that I'm going to be screen sharing that recording, which has also been pre-marked as Exhibit 4C.
Okay.
Miss Wölff, does this look like the recording of between you and the officer?
Yeah.
Does it look fair and accurate?
It does.
Changed or altered in any way?
No.
Your Honor, permission to admit Exhibit 4C into evidence?
All right, Mr. Chen, any objection?
Your Honor, I believe that this exhibit is hearsay.
Okay. What do you have to say about that in response, Ms. Elquza?
Yes, Your Honor. As it's made clear in this exhibit, this call was made from a police department, which is a regularly conducted business. So under exception 803, regularly conducted business activities, this would fall under that exception, Your Honor.
Okay, just give me a moment, Ms. Elquza. 803. Okay. Where am I looking?
Under 803 business records, 803 D, I believe.
Okay. Where is Mr. Chen? Mr. Chen, I'm listening to you.
Your Honor, I believe that she's referring to 8036, which is regularly conducted activity.
Right.
Your Honor, I believe that none of the prongs have been laid foundation for, Your Honor.
Okay, say, Mr. Chen, say no more. The objection sustained.
Thank you, Your Honor.
Yes, Your Honor. Miss Wölff, you're a private detective, right?
I am.
And this call that you made, who was it made to?
It was
Well,
made
hold
to
it,
the police.
Ms. Elquza, the exhibit is not in evidence, so let us take it off the screen. Perfect.
Yes, Your Honor. My apologies. I'm simply laying that foundation now.
Well, no, I understand that, but the exhibit gets identified, then I understand it being on the screen. It gets admitted into evidence, I understand it on the screen. Laying the foundation, I don't know why it needs to be on the screen. So continue.
Now, Miss Wölff, who was this call made to?
It was made to the police.
And as a private investigator, do police regularly keep track of their phone calls?
Yeah, they do.
Objection, Your Honor. Lack of personal knowledge.
Okay, Ms. Elquza.
Yes, Your Honor. As Miss Wölff has explained earlier in her direct, she explained that she is a private investigator and that she has worked closely with law enforcement before. Therefore, she's perfectly aware of how law enforcement functions, and any reasonable person would be aware that police regularly take phone calls from civilians and that they keep track of those phone calls. So, Your Honor, Miss Wölff could testify to that.
Your Honor.
I'd love to hear what Mr. Chen has to say about that.
Your Honor, despite the fact that Miss Wölff is a private investigator, Your Honor, there is no link between how private investigators and police do work in conjunction with.
Okay, Mr. Chen, you don't have to say any more. I have to agree with Mr. Chen. I don't see at all the connection. There is a lack of foundation. The objection sustained.
Yes,
Your Honor, move to strike.
The testimony is stricken and the jury will disregard it. Continue, Ms. Elquza.
Yes, Your Honor. Miss Wölff, you called to the police, right?
Yeah, I did.
Did you ever make anything clear to the police after restraint or after detaining Ashlock?
I made clear in that call I did not want to do the police's job for them. All I did was tie Ashlock up because that is what you do when someone threatens you
Objection,
with a
Your Honor.
weapon.
Best evidence.
Okay, Mr. Chen. I'm not sure I'm going to understand it, but try and explain that to me.
Your Honor, as Miss Wölff is talking about what is within the Exhibit 7, she has not brought the exhibit to the court's attention, and thus she cannot be testifying without doing so prior, Your Honor.
This is an exhibit you objected to, and now you're telling me that you're faulting Ms. Elquza for not bringing it to the court's attention? I'm not sure I understand any of this, but I want to hear what Ms. Elquza has to say.
Yes, Your Honor, we tend to agree. Miss Wölff is simply just saying here what she had told the police before, which she's not explicitly stating quotes from the exhibit or anything like that. She's simply just trying to make clear what
let's say no more, Ms. Elquza. I follow you. Mr. Chen, I don't follow you on this particular one. Your objection's overruled. Continue,
Yes, Your
Ms.
Honor.
Elquza.
Yes, Your Honor. Now, Miss Wölff, was there something that you tried to make clear to the police?
Yeah, I said I did not want to do the police's job for them. I wanted to keep Ashlock from hurting other people, and I wanted the police to come take over.
Had you spoken with the police about the Ashlocks before that night?
I have. I've been working for a while with investigator Corleone, giving them tips about the Ashlock family and the crime they've been involved in, including details about their operations.
And do you know what happened to Ashlock after they were taken into custody?
Not exactly. I do know, though, that Ashlock has been cooperating with the police and is getting some protection in exchange for her testimony. Testimony against me.
Thank you, Miss Wölff. I have nothing further, Your Honor.
Okay, cross-examination, Mr. Chen.
Yes, Your Honor. Your Honor, may I begin?
Cross-examination, Mr. Chen.
Good evening, Miss Wölff.
Good evening.
You recall writing a deposition before coming to court, correct?
Yeah, I do.
You mentioned how Ashlock pulled a knife and it aggressively exploded, correct?
Yeah. After I tried talking to Ashlock, Ashlock became angry with me.
And did you mention this in your deposition?
No, I didn't.
So let me get this correct. You had an opportunity to mention how she threatened you with a knife, yet you did not, correct?
It's my Fifth Amendment. I don't have to say everything.
But that's a yes to my question, correct?
Yeah, it is.
Now, let's continue by talking about you. You're a professional detective, right?
Yeah, I'm a private investigator.
Private investigator. And you moved to Corleone town to track down the Ashlock family, right?
I did.
Part of this was because of a man named Mark Volkovic, correct?
Uh, that's right. I was there for Jay Kuang. Jay Kuang killed my best friend.
And Mark is your best friend, correct?
Yeah.
So let's move on to the incident on March 11th then. At the time of the incident, you were independently investigating the Ashlocks, correct?
I was investigating Jay Kuang.
And Officer Capolino called you at approximately 10:50, 11 p.m. that night, correct?
She did.
That call, she did not instruct you to detain Cotter Ashlock, did she?
No.
In fact, you've been warned before not to involve yourself in Ashlock matters without police oversight, hadn't you?
Right. But I'm a private investigator. I can still conduct my own investigations.
I'm sorry, I'm asking whether or not you had been warned. That's a yes, correct?
Objection, Your Honor, as to 801 hearsay. May I be heard?
Okay, go ahead.
Your Honor, specifically to the statement that opposing counsel is bringing up of being warned not to involve herself with the Ashlocks, that would be an out-of-court statement used to prove the truth of the matter, Your Honor.
Okay, I want to hear what Mr. Chen has to say.
Your Honor, first of all, I believe that there is no truth value within this statement, as it is simply a demand. There is no truth of the matter. Rather, it is the demand that is being made, Your Honor. And second of all, it is being used to show the effect on the listener, Your Honor. In this case, after being warned, Ms. Wölff would have taken certain actions.
If I may, Your Honor.
No, no. I didn't candidly follow you completely, Miss Elquza, but in fairness, I followed Mr. Chen even less. So therefore, the objection is overruled. Continue, Miss Elquza.
Now,
excuse me. Continue, Mr. Chen. Let me be clear. The objection is sustained. Continue.
all right. Now, I want to move on and talk about Ashlock. You believe Ashlock was a threat simply by being present, correct?
I was investigating Jay Kuang, but I thought Ashlock was wrong for violating her parole.
Right. But let me be clear. You did not witness Ashlock assault anyone, correct?
No. Not on the street. Ashlock did try to assault me in my basement.
Correct. Now, you did not see her, break into private property, correct?
No, all I saw was her violating parole.
All right. Now let's talk about the actions that you took that night. You didn't call the police immediately when you saw Ashlock, correct?
No, I was conducting my own private investigation, so I asked her to come inside, and we were talking.
Right. You wanted answers for yourself, correct?
I was investigating a criminal.
But you mentioned earlier in your direct examination that you were seeking answers by talking to Ashlock, correct?
Yeah, that's right. I was seeking answers about Jay Kuang, who killed someone.
Right. Now, that's why you confronted her yourself, correct?
We talked. Ja.
Right. And after you talked, you restrained Ashlock in your basement, right?
After we talked, and after Ashlock tried to stab me, I restrained her.
I'm sorry, it's a yes to my question. You did restrain Ashlock after you talked, correct?
Yeah, but only after she tried to kill me.
You also did not call the police immediately after restraining Ashlock, did you?
No, I did.
You did immediately.
After I restrained her, I called the police.
You called the police immediately after restraining Ashlock, just to get this 100% clear, correct?
Yeah, within 5 minutes.
Now, Your Honor, may I screen share the case packet, Your Honor?
By all means.
Please allow a moment for the technical to bring up the screen share. Right. Your Honor, let the record reflect that the prosecution is now screen sharing what has been pre-marked and pre-admitted as Exhibit 2.
Okay.
Ms. Wölff, you understand what you're looking at, correct?
Yeah, I do.
This is a questioning, right?
It's the recording.
Right. And so you questioned her before you called the police, correct?
I did.
Right. And this was after Ashlock was tied.
No, it wasn't.
Could you
I
please?
know Ashlock said that. I know she said that on the recording, but I didn't tie her up and during that recording.
I apologize, Your Honor. May the prosecution bring up another piece from the case packet?
Go ahead. This is your time there, Mr. Chen.
Thank you. I apologize, Your Honor. There's maybe some technical difficulties on our end, if that.
But that doesn't help you with the clock, Mr. Chen, so keep on going.
That's all right, Your Honor. In the interest of time, I'll continue to press on, Your Honor. At this time, the prosecution would like to bring up Exhibit 2 once more.
Okay.
Now, let me also get this straight. Miss Wölff, you threatened to physically harm Miss Ashlock, correct?
No.
I'm sorry, could you read the line that starts with, I know I can be?
I know I can be, what do you gangsters say, very persuasive when it comes to criminals.
Right. And you said this while Ashlock begged for you to free her, correct?
I don't believe so.
Could you read the final line for me?
I want you to untie me before I spill a word.
Thank you. No further questions, Your Honor.
Okay, Ms. Elquza, any direct examination?
Yes, Your Honor.
Go ahead.
Miss Wölff, opposing counsel asked you a lot about why you didn't mention you were the one actually being threatened by Ashlock in your deposition. Could you explain why?
Ja, they asked me questions, and I answered them. They just asked me to authenticate evidence on that deposition. They never asked me about my story.
Miss Ashlock, about your story, opposing counsel asked you a lot about the timeline of events and, about being untied or tied. When did you actually tie up Miss Ashlock?
I tied her up right before I made the call to the police. At first, I invited her into my house, but I only tied her up after she tried to kill me.
Thank you, Miss Wölff. I have nothing further, Your Honor.
Okay, Mr. Chen, any cross-examination?
Yes, Your Honor. If I may begin.
Go ahead.
Good evening again, Miss Wölff.
Good evening.
Now, opposing counsel has asked you why you did not mention the threats that you were faced with on your deposition. However, you were able to speak on it, correct?
Yeah, I was physically able to.
Right. And yet you did not mention it still, correct?
They didn't ask me.
But you did not answer, you did not contribute that, correct?
Yeah, that's right.
All right. Thank you, Your Honor. No further questions.
Okay, thank you. The witness is excused. Thank you, Ms. Wölff. Does the defense have any other witnesses?
No, Your Honor, we rest our case in chief.
Okay, just give me one moment. Okay, we are now ready for closing arguments. All right, let's start with the prosecution.
May I proceed, Your Honor?
By all means, please proceed, Mr. Patel.
Thank you. May it please the court. It wasn't protection, it was possession. Let's begin by discussing the burden of proof. Today, we at the prosecution have the burden to prove beyond a reasonable doubt that Nova Wölff both willfully and unlawfully restrained Cotter Ashlock, and that she hindered a police officer's investigation. Now, we gladly accept these burdens as we know that we've proven both of these things true. This is because of what the defense has not told you. The fact that Cotter Ashlock was brutally kidnapped and tortured in just one night of being in Corleone. The defense never mentions the fact that Nova Wölff was educated, she investigated, and then she escalated. First, Wölff was educated. Ladies and gentlemen of the jury, today you heard from Officer Larry Capolino. You see, Officer Capolino warned Wölff countless times that she would not hesitate to arrest Wölff if the vigilantism ever went too far. And that warning matters, because this was not confusion, nor was it a split-second mistake. This was a meticulously planned kidnapping. When somebody knows where the line is drawn and still chooses to push past it anyway, that is not protection. That is possession. Secondly, Wölff investigated. After listening to the officer, we called up Cotter Ashlock to the stand. Ashlock spoke about the horrors she saw in the basement that night. She told you that she was attacked, restrained, and hindered. This all points to the fact that what we're here for isn't a case of protection. And lastly, Wölff escalated. Wölff knew the consequences. She broke the rules and then she took action. Wölff's movements were planned. She attacked her. She restrained her. She locked her in a basement. That is not detaining a threat. That is taking control of another person's body. Nobody is above the law. And the law is clear. You do not get to take somebody's freedom. What makes them a human? Just because you believe you're right. What we heard about today was possession. Ladies and gentlemen, this case is not complicated. No matter how it is described, the law draws a clear line. Nova Wölff was educated, she investigated, and then she escalated. And when somebody takes possession of another human being, when they cross the line of ensuring others' safety and seeking personal benefit, the law calls for accountability. That is why, on behalf of the state, I ask you to return the only verdict that reflects the truth. The only verdict that reflects the pain Cotter Ashlock endured. The only verdict that is just. Guilty. Because Nova Wölff did not give protection. She took possession. Thank you.
Okay, thank you, Mr. Patel. All right, let us now hear from the defense.
Yes, Your Honor. Cotter Ashlock, framed to stay free. When I first stood up in this courtroom today, I introduced myself. I said, "Good morning, my name is Daniel Elquza," and I didn't stutter. I didn't pause. I didn't have to think too hard about it because there was nothing else to say, because it was the truth. When you have nothing to hide, the truth doesn't change, no matter who asks, when they ask, or what they ask. And when Miss Wölff took the stand today, and we asked her why she was here in court, she told you one thing. She wanted the truth to come out. Members of the jury, there have been a lot of words used today in trial, but one line specifically stuck out to me. Trust the body more than the biopsy. Those were Miss Ashlock's words on her cross, as she said repeatedly. But members of the jury, the biopsy is the evidence, and in this case, you cannot simply ignore the evidence. That's not how the law works. So let's talk about what the evidence actually showed us today. Now, Miss Ashlock, she claimed that she was tied up so tightly that she could not move. Yet, when I asked her on cross how somehow she managed to pull out her phone and hit that record button, she had no response. Miss Ashlock, she claimed that she was hit in the head, yet when Inspector Capolino confirmed on cross, no head contusions were found. Now, she claimed that Miss Wölff was the one who threatened her with a knife and smashed her phone. Yet again, members of the jury, the evidence showed you something entirely different. Miss Ashlock's fingerprints were on that phone and were on the knife, not Miss Wölff's. Members of the jury, Ashlock's accusations have entirely collapsed during this entire trial. Now, the state tried to make something clear to you, that it wasn't protection, it was possession. But again, the evidence shows you something different. It wasn't possession, it was prevention. You heard from Miss Wölff today that she did what any citizen is allowed to do when witnessing a crime, to stop it. And as you heard from Miss Wölff, that crime was directly against her. Cotter Ashlock had a knife and threatened to kill her with it. Does the prosecution expect Miss Wölff to just stand there and do nothing? To allow the threat to continue? Of course not. Members of the jury, Miss Wölff had no other choice. She acted to protect herself and to protect the community around her. Now, the prosecution gave you 3 reasons they say Miss Wölff is guilty: educated, investigated, and escalated. Now, first, educated. Inspector Capolino, though, testified that Miss Wölff had been warned not to involve herself with the Ashlocks. But as we made clear in that case law, being warned about criminals does not mean you lose the right to investigate or to protect yourself. It doesn't mean ignoring a threat that's happening in your own home. Now, second, investigated. The prosecution says that Miss Wölff was stalking the Ashlocks. But you heard why Miss Wölff cared about the Ashlocks at all. The Ashlocks murdered her best friend. Now, we agree with the prosecution on this point. Miss Ashlock was vengeful. But it matters to who? Not to Cotter Ashlock. Heck, she never even met Cotter Ashlock before that night. Miss Wölff was angry towards a different family member. And members of the jury, as much as the prosecution would like it to be, revenge is not a crime. A crime is a crime. And Miss Wölff did not commit one. Now, third, escalated. The prosecution told you this whole story about an attack from behind and the horrors of a basement. But again, the evidence tells a different story. The injuries weren't there, the fingerprints weren't there, and the recording should not exist if Ashlock's accounts were true. So the real question is, members of the jury, why would Ashlock lie? Because she needed to stay free. Ashlock was a parole violator. She admitted she was somewhere where she wasn't allowed to be. And if she walked out, she would go back to prison. She needed an escape. And Nova Wölff became her scapegoat. She framed to stay free. Members of the jury, today all day, it has been the state who bore the burden of proof. They had to prove beyond a reasonable doubt that Miss Wölff unlawfully imprisoned Ashlock. We also had something to prove to you. We had to prove to you that Miss Wölff acted within the law, and that's what a citizen's arrest allows. And the evidence shows exactly that. So members of the jury, this is the verdict form that you will receive. You will be asked whether the state has proven unlawful imprisonment beyond a reasonable doubt, but ask yourself, where's the restraint before the knife? Where's the proof she couldn't leave? And because the state hasn't proved that, your answer is no. Now, same thing with, unlawful imprisonment. No interference has been proven beyond a reasonable doubt. So again, you should answer no. But you would also consider our affirmative defense, performing a citizen's arrest. You heard exactly what the law allowed. She witnessed a crime, she restrained the person responsible, and she called the police right after. So you should click yes. Members of the jury, she framed Nova Wölff to stay free. And for those reasons, we ask you that you find her not guilty. Thank you.
Okay, thank you, Ms. Elquza. Any rebuttal from the prosecution?
Yes, Your Honor.
All right, please proceed, Mr. Patel.
Thank you. Today, the defense has told you that Cotter Ashlock framed to stay free. So let's discuss these things. Firstly, freedom. Freedom is what makes humans human. It's simply what separates us from livestock. Now, the only freedom that we saw today was the freedom which was taken from Cotter Ashlock. The freedom which instantly dissipated once Nova Wölff had tied her up in her basement, refused to let her leave, and began interrogating her. Now, if Nova Wölff's main focus was to give protection to her neighbors, there would simply be no issues. We would have no reason to be here. However, this is not a case of protection. It's one of possession. Then framing, defined as the fitting together of pieces to give a structure. The only pieces which were strung together were the details regarding the death of the defendant's best friend. Nova Wölff said it herself. When asked on the stand, she said, "I just wanted answers about Mark's death." So I wish for you to ask yourself, does PI stand for private investigator or for personal interest? Also, does something as simple as seeking answers require tying somebody up? Does it require threatening somebody with a knife? It simply does not. The defense continues to play a game of he said, she said. They claim that all of Miss Ashlock's claims are untrue and have no backing. However, the credibility of their witnesses is no better. Mr. Reeves is an elderly man who witnessed things through the dark and behind walls. And Nova Wölff hates the entire Ashlock family. So before you deliberate, I once again like to remind you that this is not a case of protection. It's one of possession. Thank you.
Okay, thank you, Mr. Patel. With that, I would ask everybody to please put your screens on so we could see everybody and we could finalize our scoring sheets.
All right, we're ready for comments. Judge Noodleman, take it away.
Okay, well, I did. I'll speak. I'll speak last because I did most of the talking. Let's hear from Marcus first.
Overall, I'm sure you'll hear this every mock trial competition, but you guys did really great. I normally don't judge mock trial too much. I'm just like a competitor or coach, but then hearing like a case for the first time and hearing all your guys' presentations, it really shows how much one, presentation matters, and two, how clear a case can be at such a high level of presentation. So really great job to everyone. I'll give it to Meghna next.
Yeah, I just want to say impressive performance by everyone. I mean, I was pretty entertained. I loved how all the witnesses had their own little characters and personas. That was really enjoyable. Thought the attorneys were really impressive on the objection responses. Um, yeah, I mean, if I had to give like one piece of like advice, I think everyone, especially the witnesses, could maybe speak a little louder and clearer and maybe slow down a little bit. Just because obviously on an online format, it's a little difficult to always hear everybody. And I feel like this is I feel like you guys aren't thinking as much about projection because obviously you're not the attorneys, but it's important for you guys to be loud and clear as well. So all the information gets across. And then for attorneys, I would say great job on the objections. I loved how many you guys threw out there. It really showed your command of the law and of like just the information that you were working with. So that was really impressive. I would say one thing though is make sure you're not going a little overboard with it. Think in some cases there were like a lot of consecutive objections that weren't always necessary. I feel like once you get to these higher levels of competition, it's great to like start sensing which objections are the most effective and the most helpful to your case, and which ones are the smarter ones to make, and then which ones might seem a little just like not quite like necessary. Like it might just seem a little too much, or you're being a little too petty with like an objection. Like maybe you don't need to make that objection when you've already won maybe two or three others. So it's just things to think about. But overall, just amazing performance by everybody.
All right, folks. Judge Noodleman.
Yeah, no, and as I think I said, I've never done mock trial as a competitor. I've only had the thing of judging it, and to be honest with you, I treat everybody in this sort of thing the way I've been treated over the past 30 years from judges that deal with me. One of the most important things is you have to have a good command of the rules. And I keep them, and every judge I've been in front of keeps as a book right next to them. And when someone says such and such a rule, trust me, they don't remember every part of 8036. They have to look at the rule and see, did you, for example, Mr. Chen, qualify the witness as an expert under Rule 702? So I'm going to look at Rule 702, especially when someone calls you out on that. So there were a number of what I'll call bright line rule things that I didn't totally understand. There was some improper character evidence that had come out about Wölff, but nobody raised the objection, and I'm not going to raise the objection because I'm not getting scored. The best evidence rule is not one of your stronger ones, but you do want to be careful because a lot of people here would throw in best evidence, but at the same token, they, were arguing against the exhibit. So why are you saying, well, they're not giving you the best evidence? Then when they give the best evidence, you object to the exhibit. That just doesn't ring true to anyone who's following all this. I was very impressed with Ms. Wiederkehr over there. I thought that was terrific how you stuck with it on Exhibit 9. I've seen however many of these trials, and I was very impressed how you stuck with it, and you went back and you very unflappable, and it's very important if you don't lay a foundation the first time, there is nothing saying. I mean, it's nice that you ask permission of me. I'm not going to tell you how to try your case. So, but more often than not, people give up. Okay, and you went back, if not once, maybe twice. Okay, and finally got it right. Okay, and I was very happy to see that. When you cite Rule 403, Mr. Patel, you want to look at Rule 403 because it says the probative value is substantially outweighed. So had you looked at that, you would have said, oh, no, you didn't argue against 403 adequately, which is why I sustained that objection. Had you said, this is a very high bar, Your Honor, and it was not substantially outweighed by the prejudicial effect, I would have then said, you're right, Mr. Patel, but I'm not going to make the argument for you. So the argument was properly raised as 403, but there was a response, which is why, again, you always want to look at the rule. And you want to go back and look at the stipulations. When they cited the stipulation 7, okay, you could have, even though it says it's admitted, if you read the stipulation, it does say you still reserve the right to object if it's prejudicial. And there were things that were being said there that were arguably prejudicial. But nobody looks at the stipulation. So had you gone back and looked at the stipulation, you might have said, hey, wait a minute, you just assumed, admitted, and it could be no objections. And that just wasn't so. I also didn't understand, Ms. Elquza, why you didn't want to get the plea deal document in as an exhibit. You have to remember, the reason why you want to have these exhibits is they go to the jury, right? So if an exhibit is in, the jury will get to see that plea deal. It'll be in front of them, and that's a little bit more compelling from, your point of view. Now, there were a number of times, I did not understand this either. There were statements from Nova Wölff. Nova Wölff is a defendant, right? So in theory, the exception there, your hearsay, is you could say it's a statement of a party opponent under 801D2. Nobody said that. Instead, we got off on excited utterances, which happened to a fit as far as I'm concerned, and those were a good objection. But people every time Nova Wölff said stuff, that you had a good argument to say that's a statement of a party opponent. Or back when I went to law school, it was party admission, and that would be what everyone would remember it by. But the fact is, nobody said that. So I did not understand that. Mr. Patel, okay. Where's Mr. Patel? How old do you think I am? Take a wild guess.
You really want me to answer?
No, I'm lying. How old do you think I am, Mr. Patel?
Wait, what was that?
How old do you think I am? Age?
Probably like 25.
Okay, well, okay. I just turned 57. Okay, so here you are asking a question about older people. Okay, and having dim perceptions and dull abilities. You might have old people on the jury who might take a little bit of umbrage at that. Okay, or the judge who might get pissed, but you're not really meant to convince them. But you want to be careful about that as a practical matter. Okay, I mean, in this case, you have a lot of youngsters like Marcus, or whatever, up there judging, and they may not wince at that sort of thing. I'm thinking, my goodness, what if there's older people on the jury, or what if there's an older judge, and he's asking a line of questions about, older people abilities. So it's probably not a good line of questioning, as far as I'm concerned. To do that, and I have news for you. Somebody could have objected back to you and said, 404, it's improper character evidence, just because, what do we, it's just a propensity that old people all have this character trait of being, dull in senses. I mean, it's a tricky thing. And then this business about he was warned by the police. I kind of wanted to hear, and nobody said this, so I didn't say it. I wanted to know what the statement was. I couldn't figure out what the statement was. That was the out of court statement. So when people do, a lot of times questions and comments and things are brought out, people, muffle what the statement is so they avoid the objection for hearsay. I kind of wanted to hear that, but everyone kind of assumed there was a statement, that we were arguing about what, the statement was, without anyone ever saying, well, what the actual statement was, or there was no statement. Because a hearsay is an out of court statement for its truth. I was on the notion of old witnesses. I thought Mr. Reeves did a wonderful job down there. As an older fellow, I understood everything he said. He was nice and slow and very clear, and I kind of liked that character. I thought it was appealing to me. But the most important takeaway here is have those rules handy, because and again, 803.6, yes, Ms. Wiederkehr, you gotta know the exact rule. The judge has it, everyone has, the adversary had it, and I will tell you, this is your really sharp mock trial teams know these things really cold, those different rules, and they pull them up. Now I've done two of these things. Nobody brought up the medical one, whatever it was, 803.4, the business about the medical record. I thought that was very good. And the other thing is, what you did is you helped get that document in by showing that the witness got it. Okay. Other trials I've seen, they haven't made that distinction. And, what happened is people kind of just assumed that I'm saying, wait a minute, nobody, and I commented, I said, you have to remember, you're trying to get in a medical record through a policeman. I don't know how that happens. Now here, you did make that connection, which was very good, which I was very impressed by. But that doesn't always happen. People just, everyone's so close to the problem. Everyone's kind of assuming that, oh, by the way, we can just get in anything by someone saying, how on earth? Think about it. How on earth is a policeman able to authenticate or talk about with personal knowledge that medical record? But you brought out that they got it, and they received it, and then that was what they saw, and it didn't change, and that was very helpful. So that was very impressive. So yes, I agree. Everybody did a very good job, and I thought, you should all be very proud of yourselves. The good thing about mock trial, and I will tell you, I used to judge so many of these things, and I was interfering with my business life, and I've dropped most of the judgings I do. I probably only judge this competition, and I have an Orcs one in Iona College in another week, and those are probably the only two things. I used to go to Yale and Princeton. It got too crazy, but you guys do a great job, and this is very for the most part, I'm very impressed with these. I forget that you're high school students, and I think you do a really very comprehensive job. And the good thing is, the more and more you do this, the better and better you get at it. And in some sense, I'm sure it's fun. So those are my comments.
Thank you all so much for your time, your volunteerism, your expertise. Time for announcements. Let's begin with the MVPs. First, there was a split decision on MVP attorney. Your runner-up with one vote from the prosecution, Mr. Syler Patel. Congratulations. Winning the MVP attorney on a 2-1 decision from the defense, Ms. Dana Elquza. Congratulations. For witnesses, it was not a split decision. By unanimous decision from the defense, Mr. Johnny Shiell. Congratulations. This was a close round. While one ballot was decisive, the other two were close single digits, and you're going to see them right after. Congratulations to both teams, but advancing to the semifinal, the final four, the defense. Well done to both. Great work. We'll see you there in semis.